Katy Perry loses a legal dispute with an Australian fashion designer in federal court. After a protracted trademark fight, an Australian fashion designer defeated pop diva Katy Perry in court. The Federal Court of Australia's hearing on the case came to an end last Friday, and the judge didn't announce the verdict until Thursday. Katy Jane Taylor, who designs and markets clothing under the name Katy Perry, first filed a lawsuit in June 2009 to defend a trademark she owned. Ms. Taylor and the American pop artist have frequently argued about who should own the rights to and profit from the homophone moniker. Beginning a lengthy written judgment, Justice Bridget Markovic stated, "This is a tale of two women, two youthful desires, and one name." According to the judge, the designer's claims of trademark infringement were partially successful. She discovered that infringements happened during Perry's prismatic tour in Australia in 2014 and 2015, at pop-up shops there and in Sydney, as well as on the website of the goods company Bravado. The judge determined that Perry's company Katy Perry was responsible for the infractions. Additionally, Perry herself was shown to have violated the trademark through a number of tweets and Facebook postings in 2013 and 2014 marketing goods and pop-up shops. 8 different channels of garment sales were included in Ms. Taylor's allegations of trademark infringement, including Cotton On, Myer, and Target after 2013. The judge determined that her accusations were unfounded despite the fact that the tour, pop-up shop, and Bravado website were all implicated in the infringements. I Kissed a Girl, Katy Perry's breakout song from that year, and its follow-up success, Hot and Cold, launched her onto the music scene. The same year, Sydney-based Katy Perry, who at the time also went by the name Katy Howell, filed a trademark registration for her collection of t-shirts, jeans, and accessories. After starting Katy Perry in late 2006, Ms. Taylor operated without incident until June 2009, when she received a cease and desist letter from the musician's management due to the brand's similar name. In the same month that the legal notice was given to Ms. Taylor, Perry, who had been having economic success on the Australian charts, also submitted an application for a trademark for the name Katy Perry. Perry used her mother's maiden name for her performances in 2004, therefore her legal name is Catherine Elizabeth Hudson. Her lawyers argued that Ms. Taylor should abandon her loungewear line since the name of the company was misleading or deceptive. In a blog post from 2020 looking back on the time, Ms. Taylor stated, "I had no knowledge of the singer at the time." In July 2009, Ms. Taylor's apparel brand for Katy Perry was formally registered with Intellectual Property Australia. Perry's team submitted a notice of opposition at the time, and IP Australia arranged a hearing between the two parties. However, the hearing was ultimately cancelled. Also unsuccessful were efforts to develop a coexistence agreement. A little more than 10 years after the initial altercation, Ms. Taylor filed a lawsuit against Perry and her businesses Killer Queen and Katy Perry with the Federal Court of Australia. Since the first altercation, Perry has made 4 trips to Australia as part of her international tours. Allegations that Perry's products were substantially identical with, or deceptively similar to, Ms. Taylor's trademark were brought before the court. The celebrity did not show up in person, but Stephen Jensen, her manager, testified on her behalf. The singer already had a reputation in Australia before the designer claimed a legal claim over it, so Perry's legal team filed a cross-suit against Ms. Taylor in December 2019 asking for an order to have the designer's trademark annulled. Although there was evidence that Perry intended to utilize her name in connection with apparel, Justice Markovic decided this month that Perry's notoriety at that moment was in relation to entertainment and music. The judge stated, "I am not satisfied that use of would be likely to deceive or cause confusion due to that reputation." The judge stated that by late 2019 there was no evidence of any such confusion despite both ladies dealing for roughly 10 years. This was in response to whether the designer's trademark may have caused confusion more recently due to Perry's international prominence. Cross-claim was rejected. According to a representative of IP Australia, Perry still owns 5 registered trademarks in Australia.